I'm Luke Silva from Foley & Lardner here in Boston. With me is Alexia Badad and Shabi Khan. We'll talk about a few legal issues on augmented reality. Brief intro, augmented reality touches so many aspects of our lives. We're not going to try to, go through everything, just sort of scratch the surface here with a few issues, mostly around intellectual property law, privacy, that sort of thing that we thought would be interesting to the audience. Well, I'll just get started. I was going to talk about a litigation that people might be familiar with. There's a case that was filed against Niantic, the maker of Pokemon, about a year ago now, by several plaintiffs in different states throughout the country. It's this virtual trespassing case that people may have heard about. So, at the height of sort of the Pokemon Go boom, people were sort of in droves going out into public parks and all kinds of in different areas, and including private property. And so a bunch of plaintiffs brought a case against Niantic, alleging that sort of their property was damaged from all these people coming and trespassing on their land. So this is a case filed about a year ago out in California, but it was filed by several plaintiffs in different states. So these plaintiffs are alleging that Niantic should be liable for the trespassing that took place on their property. So, the case isn't that remarkable in that, you can be liable if you force somebody. So this is why we're here. We don't want to be this guy. So, it's not that remarkable that you could be held liable or held accountable if people trespass on your property and they cause some damage. The interesting thing about this case is that the plaintiffs are actually alleging that Niantic committed this form of, quote, virtual trespassing. So that the placement of digital elements in the augmented reality video game is itself a form of trespassing. So the theory being that, Niantic, because they can control where these elements are placed, and these elements have a, quote, physical location, they have GPS coordinates associated with them, Niantic should be liable when, people follow these elements onto private property and do damage to that property. It's interesting in the sense that usually trespassing is a physical incursion into somebody's land, not incursion through, maybe light or vibration or something like that, and certainly not through a virtual element like this. A wrinkle here is that, like I mentioned, this is a bunch of different plaintiffs from different states, so different state trespass laws apply to the question. So we're not really sure, how this will be resolved. The court had a chance to dismiss the case very early on and did not do so, suggesting that maybe this claim does have maybe a little more legs than some people would have thought. And I want people to just think about this for a second. I mean, we've heard about all these great potential implementations and implementations of AR. Even the last panelist in the marketing panel talking about wayfinding at Lowe's. If you are in a Lowe's store and you're using a wayfinding app, that's great. Well, what if the owner of that Lowe's store, and presumably Lowe's rents space from the owner of a strip mall, that strip mall owner would potentially have to sign off on the placement of these virtual elements on that property. Likewise, a supermarket. Say you have an app that allows you to go through a supermarket and see information about foods that you might want to buy in the aisles of that supermarket. Well, maybe Whole Foods gave you permission to do that, but do I need to go get permission from the owner of every strip mall in which a Whole Foods is located? So they're not going to say that I'm trespassing on that strip mall's property by placing my virtual elements there. So, I think this is a case that has potentially far-reaching implications for augmented reality, especially in the advertising and marketing space. And like I said, we'll see sort of where it shakes out, in the months or probably a year or so to come. Another issue I want to talk about also relates to sort of where you place your virtual content, and it has to do with advertising. So here we are in, I'll set the scene. I'm in the year 2025, enjoying a Red Sox-Yankees game in Yankee Stadium, and maybe I'm wearing my Meta 7 goggles and enjoying an enhanced baseball viewing experience. So there I am sitting in my seat in left field, and perhaps I'm getting information about players as they enter the batter's box, statistics, et cetera. Perhaps I'm getting, using a technology that helps me to follow the baseball. So maybe the baseball can light up and I can, get that, through my AR headset. That's great. And then perhaps I gaze over to the right field wall here and by the foul pole, and I see among the other advertisements sort of a familiar sign that I know from my time in Boston, and some of you may recognize. So, that's an example of maybe placing augmented content on, a physical location that maybe the owner of that physical location would object to. And it's a silly example, but I think it is an important example, and it's one that often arises, especially in the context of sort of native advertising. So you're on CNN.com, maybe you see an ad that's made to look like an article with bold print at the top and a headline and maybe some text and a photograph. That's fine as long as the purveyor of that advertisement identifies the content as paid content. So this relates to a law, the Federal Trade Commission Act, that prohibits unfair and deceptive practices in the context of advertising. So this can certainly arise in the AR context as well. If you're placing an ad on a physical location, basically you need to make it clear that the commercial nature of that content. And the rule here is that the ad cannot mislead the potential consumer in a material way about the commercial nature of the ad. So this could present itself in many contexts, and the FTC has not given us every possible scenario, but we do know a couple of things from one of the statements that the FTC has put out, a guide for business in the context of VR. So having, for example, content in a VR video game on a billboard, it's not necessary to tell the consumer that that's paid content, because it would be clear that something on a billboard is probably an advertisement. Similarly, if a character in a VR video game is wearing branded clothing, or perhaps if there's product placement in a video game, like they're drinking Coca-Cola, probably you don't have to disclose that that's paid, because it's not really material to a consumer's decision about what they're going to buy. They're playing a video game. However, if you are placing content in someone's environment, and it's not, and maybe it is material to a decision being made, such as the supermarket example, you probably do have to make it clear that that's paid content and not just native to the surrounding area. So with that, Alexia's going to talk about a couple other issues, and I'll pass it along.
Thanks, Luke. So hi, my name's Alexia. I come from a media law boutique based in New York. Really happy to be here. So you've heard about really exciting things, sitting on a bench next to a virtual elephant, and now we get to talk about privacy and copyright. Yay. So privacy, another lesson that we learned from Pokemon Go was collect what you ask for. In July of 2016, it became clear that people that were logging in to Pokemon Go with their Google accounts were actually granting Niantic access to their entire account, and including the ability to read and send emails. And this was fixed, and we kept happily hunting for Pikachu. But this is a good reminder of collect what you ask for. And why are we bringing this up again now? This is because of biometric data and the increased attention that collection of it is getting now. So this audience is very familiar with biometric data, but what we're talking about here are eye scans, fingerprints, voice prints, hand recognition, facial recognition. So why now? At the federal level, this isn't regulated. There's no statute at the federal level about what you're doing as an AR developer or any company that's collecting biometric data. There are certain federal statutes about collecting information that relates to credit cards, that relates to children, that relates to health, but they haven't, at a federal level, they haven't touched biometric data yet. At a state level, though, there's been activity in the past 10 years. It started with Illinois in 2008, Texas in 2009, and most recently, Washington in 2017. And these states now have specific statutes saying what you need to do if you're a company or a developer who's collecting biometric information. So what does this mean if you're marketing your product there, or you might? A couple of things. One, you have to disclose the fact that you're doing this. So in your policy, for your product, for your headset, you have to disclose that you're collecting this kind of information. The second one is you have to get consent. In one state, this has to be written, the others not necessarily, but the user has to consent to this. And another important one is also have a protocol that makes clear what you're doing with that information once you've collected it, because these statutes apply not just to collecting it, but how you process it. And lastly, keep calm and carry on. Don't panic. These statutes are not there to close your business or to close your company. There have been a lot of lawsuits, but already 2 of these have been thrown out saying, look, the company didn't exactly abide by the procedures, but you haven't shown any damage as a user, and they've been dismissed. So be aware of it, think about it, especially in these states, but it's no cause for panic just yet. And now copyright in a couple of minutes. Copyright. Why is it important for this audience? 2 things. You might want to protect the content that you're making and copyright it, but you might also want to use, and I've spoken to this with a couple of people, you might also want to use content from a third party that another party owns the copyright to, and that's not yours. This can be any of the things that are up there on the screen. So I am an AR content developer. I want to use someone else's copyright. How do I do it? 1, you can pay for it and obtain a license. The varying fees depending on what you want to do with it. Or you can fair use it, which are these magical words that appear in the Copyright Act. So what is fair use? Fair use is basically this doctrine that allows you to use someone else's work that they've copyrighted without their consent, so long as the use is minimal, and here's the key, so long as it's transformative. What does this mean? This means basically that you've taken someone else's work and you've added some kind of new meaning or new purpose to it. And you've all seen examples of this here time and time again today, because anyone who's had a slide here and a presentation with material that isn't theirs has fair used it. So that's what's let us all present with material that's not ours, but that we're giving a new meaning to or using for a new purpose. 2 examples of this to put a little bit of flesh to this concept. These are 2 cases that both went up to the courts on whether something was a fair use. The top one, Jeff Koons, the artist, used the photograph on the left and made his sculpture. The artist, Art Rogers, sued and wasn't happy. Now, by show of hands, who thinks that what Jeff Koons is transformative, that he added some new meaning to it? Court disagreed. They said, you didn't add any new meaning, you used the entire thing, you did it for a bad motive, and you did it to make money. Side note here, it's not because you're using someone's content for financial purposes that you're making money that you can't fair use it. It's a big fair use myth. So if you've heard it, that's not true. The one below, very similar, Richard Prince, the artist, not the late singer, used the photographs of many Rastafarians done by Patrick Cariou on the left and added very similar to the style you can see on the right. Same thing, went up to court. Do you think this was considered transformative? Show of hands, those who do. And it was, because the court said Richard Prince added something new and different. Didn't elaborate on that. Pretty similar, the 2, so it's a very confusing area, but that said, it's been tried and tested many times. There are a lot of examples of this, a lot of cases you can look at to see where you fall on the fair use spectrum. So it's confusing, but it's not confusion everywhere. And just an example how this might apply to you as an AR content developer. This is actually a real example in VR, but it could just as easily be in AR. There's a tourist company in New York that, very similar to what they did in London on the left, has created an experience in New York, sorry, on the left in London, has created an experience in New York where when you go in Times Square and you're there and you're looking at it, you see overlaid in Times Square the very famous photograph that was taken at the end of World War II in Times Square of the sailor kissing the nurse. And so here's the question. This photograph on the right is not in the public domain. It's owned by Getty Images. You're the AR content creator. You want to make this overlay with your phone in Times Square. What do? You go to Getty Images and pay for the license, or do you decide to fair use it? And if you decide to fair use it, how do you do that? Depends. You might add information so that it's a little bit more educational. You might incorporate this with many other photographs, old photographs taken in Times Square, so that you're adding and telling a story over time in Times Square. Many different things that you can do that would make this a fair use or not. So it's a confusing concept, but if it's used carefully and you know how to navigate fair use, it's a very useful tool to have in your arsenal as a content creator. So with that, turn it over to Xavi.
So I guess I'll start with asking the question, is this fair use? No, I'm just kidding with you guys. So this is an image of a patent application by Sony that focused on a method of laughter detection. And the idea was you show some content, you find out when somebody laughs, and if they laugh, you tag that portion of content as something funny that then they can serve to people in the future. So this is an example of things that people can protect. And so if you guys have ideas that are as crazy as this, then you guys should be filing for patent applications. But that said, let's start with the basics of what is a patent, right? So it's a legal protection which gives an inventor the right to exclude other people from making, selling, using, or importing into the country of issuance, right? And it's what's missing here is the offer to sell. So one thing to always remember is even though you haven't sold anything, but you're offering that product for sale, that counts as a violation if you're infringing somebody else's patent. So next part about that is a patent is a monopoly that's granted to you by a government for a set number of years. That can vary. If it's a design patent, it's 14 or 15 years, depending on when it's filed. If it's a utility patent, it's 20 years. But it's in exchange for disclosure to the public. Now, what does that mean? Disclosure to the public essentially means you have to provide enough information for someone else to make, or somebody with ordinary skill in the art to make and use the invention. So that doesn't necessarily mean you have to disclose the source code behind your algorithms, but give enough information that somebody could sort of make and use the invention without undue experimentation. Bunch of legal jargon, but the idea is that you're getting a patent in exchange for information. So then the question is, in a room filled with startups, why should startups file patents? And typically you get to hear answers like you can sue competitors. But the reality is startups don't have enough money to sue competitors, so this isn't really the reasons why you should be filing for patents, right? Can you file patents to prevent others from protecting your ideas? You certainly can file patents to do that, but there are cheaper ways to do that. If you publicly disclose your invention, if you write a paper and publish it, that would prevent somebody else from protecting your own idea. And then, generating licensing revenue. What people don't realize is to generate licensing revenue, you have to spend a lot of time trying to build a portfolio. Licensing a single patent is extremely difficult, and it takes away from the startup's core focus, right? So these are reasons why startups may file patents, but they're not necessarily the best reasons. So why should startups really file patents, right? That's the real question. And the primary reason why as a startup, you want to file patents is to stimulate investment or acquisitions. VC funds or angel investors will ask, is it protectable? If you go to Shark Tank and you hear Lori Grenier, you'll ask, do you have any patents? That's the question they ask. So it's really to invest, to stimulate investment or acquisitions. Can it deter patent infringement lawsuits? It's very hard to statistically prove that, but if you do have a pretty robust patent portfolio that other people may be infringing, it's likely that they don't want to sue you out of the fear that you're going to countersue. So, that's another reason. It can facilitate joint ventures and partnerships, right? You can, if you have protectable IP and you want to sort of negotiate with another company to sort of build a product together, coming to the table with your own IP helps facilitate those joint ventures, right? And then can it increase leverage over a partner? So you've got your own IP, they really need to now work with you because you've got something protected that they can't get elsewhere. So these are some of the reasons why startups should really be filing patents. So when should you file patents? If you're looking for international protection, you need to file before you publicly disclose. So before you come out and you do your trade shows or you're at a conference, you're demoing your product, you might want to file before that. In the US, you have a 1-year grace period. So if you disclose the invention today, you have up to 1 year to file a patent application to preserve your rights for patents, at least in the US, right? So then you move on to after you've got your patents and file, the next question is what do investors want to know if you're a startup, right? They want to know whether you've figured out what is patentable in your invention and whether you've taken the steps to protect it. But then they also want to know, are you infringing anybody else's rights, right? And it's not so much anybody else's, because there will be a bunch of patent trolls ready to sue you once you make it big. So it's really like, are your main competitors a threat to you? And you just want to make sure that you've determined to infringe, determine whether you infringe your competitors' portfolios. This is just a slide showing the growth of AR patent filings. So in the year 2015, there were 33,000 patent applications or families that were published in the year 2015 that referenced augmented reality, right? Compare that to 1330 or 1330 in 1995. So I thought I'd give you guys a synopsis of what Magic Leap's patent portfolio entails and how big it is. And so they've got, let me just quickly go through this because I think we're short on time. But they've got over 400 patent assets. They've got 31 issued patents. They've got 250 pending applications, over 120 international applications, 9 design patents, and their earliest patent filing went back to December or Christmas Eve 2010. They released Magic Leap 1, or like the images of Magic Leap 1, December 20th, 2017. However, if you went through their patent filings, you might have been able to see what they were coming out with before December 24th. In fact, these images were first published September 19th, but there were some patent filings that were showing these images as early as August of 2017. And so, patent applications of your competitors can be a good tool for you to figure out what they're trying to do and where they're really trying to protect their product. Some of the things that you can protect in the AR specific space, and I just went through like one of Magic Leap's like large patent applications to see what they were sort of covering. So they've covered stuff along, the idea of virtual UIs. So you use your hand and you can have virtual interfaces that can be displayed. Haptics within, using some sort of a wearable device to provide some sort of feedback mechanism. Gestures, like the use of gestures in the AR space is going to become huge. And so you can protect different type of gestures. Magic Leap has disclosed some of them, but there are other types of gestures that can be disclosed as well. And then I have a bunch of use cases that I'm not sure how we're doing on time, but I'll quickly just go through these. This is basically, Magic Leap suggested the idea of a woman going through a grocery store and she has her shopping list out in front of her in a virtual environment, right? This is a surgeon performing surgery, providing some sort of a UI image of the organ that they're treating. This was an image of basically a patient who needs to relax before the surgery, so they put on this virtual headset that transcends them into a very beachy resort to kind of help them relax. And then, at some point when they're going through physical therapy, the idea of using virtual, images or augmented images to help with their physical therapy. So these are some ideas that you guys can take home and think about whether there's things that you want to protect and what other people are protecting.
So you guys, if you need a lawyer, I recommend hiring one of these. They're all equally great. There's no loser lawyer among the 3 of them. And I really appreciate these guys seeing AR as a great opportunity to kind of support innovation. So they're not trying to squash innovation, they're trying to support it. And